SJC-11663, Commonwealth v. Jeffrey Asher.
Good morning, Mr. Gambaccini. You may begin.
Good morning, Your Honors, and may it please the Court. My name is Andrew Gambaccini, and I have the privilege of representing Jeffrey Asher in this matter. Your Honors, the issue presented in this appeal is whether the trial judge erred in reversing her own decision just prior to the jury charge and in failing to instruct on a police officer's ability and indeed the obligation to use force in the discharge of official functions, including effectuating an arrest and meeting the threat of deadly force with deadly force.
But there was no arrest. The victim was not under arrest here, right? Isn't that what sort of the problem was? Because it was not a reasonable force to effect arrest and not a resisting arrest case.
I think the Commonwealth makes the point in its brief, Your Honor, I would agree to an extent, that this is one of those situations where there is no precise moment in time at which we can pinpoint an arrest took place. The officers,
But as a trial strategy, that wasn't the strategy either. That wasn't the defense.
That is correct, Your Honor. And I think that, to an extent, is what underlays some of the, what I would submit would be the misunderstanding by the Commonwealth of the defense theory in this case. And that is to say,
what was the defense theory in this case?
It was that Jeffrey Asher was entitled to use deadly force to meet the threat of deadly force. Factually, and this ties into the notion of when the arrest took place.
As in defense of others, correct?
It's similar. It is, I would submit, a broader proposition when you're dealing with a police officer who has an obligation to use force to protect others, as compared to what might have been the situation in a case like Commonwealth versus Klein, dealing with a citizen's arrest, when a citizen does not have that duty-bound oath to transact deadly force when met. In terms of the arrest component, I think you can start the analysis at the point in time at which Mr. Jones struck Officer Trulio. That, I would submit, would be the first moment in time that there could have been arrest. Correct. When there was contact
Assault and battery.
Assault and battery in a police officer.
That would not justify deadly force, correct?
No, that is correct, Your Honor. Moving then through the continuum, when Mr. Jones was fleeing from the police officers, as they yelled, "Stop police," that could be considered resisting arrest. That might be the moment in time at which an arrest takes place. Certainly, by the point in time that Officer Settergren is hanging onto the back of Mr. Jones to try to get him to the ground to handcuff him, and then moves to the area of the second cruiser and has him against the hood as they're trying to cuff, I would submit that certainly at that point in time an arrest has taken place. Mr. Jones knows that he is not free to leave at that point in time as they're trying to put handcuffs on him.
Not for a felony at these points.
No.
Arrest for what?
At that point in time, it would have been assault and battery on a police officer and resisting arrest at a minimum. Now, when they are on the hood and Jeffrey Asher hears Officer Settergren say, "He's got my gun, smash, he's got my effing gun, smash him." At that point in time, as I point out in the brief, you have the additional potential crime of assault with a deadly weapon. From Officer Asher's perspective at that moment in time, Mr. Jones had a weapon, and there was a danger that it was going to be discharged.
He did not have a weapon. He never had it in his hand. There's no evidence that he did.
What is important, Your Honor, is what was Officer Asher's perception
based
at
on,
that time?
So here's the scenario. No felony, potential arrest, someone's running from a pat frisk. An officer says, "He's got my effing gun," and that means the other officer, based on that assertion alone, can use deadly force. Is that the principle that we're trying to invoke here? I'm trying to get what the principles would be and how you would apply it in other circumstances.
That is the principle, Your Honor, that although there is case law that deals, and this is the Model Penal Code, this is Tennessee versus Gardner from the United States Supreme Court, this is to an extent Julian versus Randazzo from this court, you have two conceptually different avenues here in which we're dealing with the use of deadly force. One is the Tennessee versus Gardner scenario, which is where deadly force is being used to stop a fleeing felon, with the potential, perhaps, of some harm to someone down the road. That's one avenue. That's not this case. This is not the use of deadly force that was used simply to stop a fleeing felon or to transact an arrest or to overcome resistance. This is the scenario that is outside the realm of the model penal code.
Why is it? Why isn't it covered by Julian versus Vendazzo and whatever it is, section 1.20, 120.7?
First, Julian was a civil case, and this court made note of that fact. There are some principles I think that can be imported to the criminal context, but I think that's an important distinction to raise. The other issue is that when you're dealing with what I would call the fleeing felon rule under the model penal code, that is the use of deadly force.
Hardly fleeing. You had him spread-eagled across the police cruiser.
I'm talking colloquially in terms of using deadly force in order to either stop a fleeing felon or to transact an arrest. This is a situation that can arise no matter what the underlying issue could be. To your Honor's point, there could be a scenario where a police officer sees an individual in a commercial area after all the businesses are closed, walks up to that individual, no hint of a crime, just suspicion. What is this person doing in this area? Walks up to that individual, asks for a name. That individual, perhaps because there's an outstanding warrant, thinks, if I give this officer my name, I'm going to jail. I don't want to go back to jail. Pulls out a weapon and points at the officer. This is not the model penal code situation. This is now a situation where, in that instance, no criminal behavior has been detected at that point in time. There's suspicion that something might be going on, but the officer is now obligated to use deadly force to meet the threat of deadly force. That was the theory of the defense below.
But that's not this case.
It's similar in the context that when Jeffrey Asher and all the cases that deal with a police officer's use of force talk about the perspective of the officer. We're not dealing with 20/20 hindsight.
Well,
we're dealing with, I'm sorry, Your Honor.
You finished, I'm sorry.
We're dealing with an officer who has to make a split-second decision in that moment. When he hears, he's got my effing gun, smash him, as he testified to at trial, he thought the next sounds he would be hearing would be the discharge of a weapon and people would be shot at. He does not have to make an observation of a gun in hand. He's entitled to rely on Officer Sedergren's comment that he's got my gun, smash him. Your Honor.
It seems to me that gets us back to the point that really what you're saying is he was acting in self-defense and defense of others, as in Officer Sedergren, or however you say his name. And that the instruction that was requested about effecting arrest, which really, its genesis is a very different context. It's when somebody is charged with resisting arrest, was confusing. I mean, what you just said seems to me to be a core defense of others kind of argument that your client was making.
It can be in some situations. The outlier here is that we're dealing with a police officer in that situation. And
I take it the officer has no obligation to retreat, quite the contrary.
That is correct, Your Honor. Police officers can be disciplined, they can be fired for running away from a situation like that.
But in the context of this case, I guess the question is, if the jury believed that the events were as were described by you, it would have been quite clear that there was no opportunity to retreat at that moment. After all, it was defense of another. If he runs, then that does not spare his fellow police officer of the risk of him having pulled a gun. It's not clear. I mean, regardless of whether or not this is a sensible instruction, how could it have mattered here?
The jury was told at the beginning of the charge that they were to accept the law as instructed by the judge. The trial judge repeatedly referenced in the context both of self-defense and defense of others that Jeffrey Asher, this defendant, had an obligation to retreat, if available, or to resort to other reasonable alternatives prior to using force and deadly force in this particular situation.
Was there any objection to the obligation stated to retreat where we're speaking about defense of another?
There was not. And I think
isn't that really the core concern here, is that when there's a defense of another, there's no obligation to retreat if you're going to be leaving the other person at that same risk of being killed?
There would be two points to raise, Your Honor. First, if the police privilege instruction had been given and this jury had been told that Jeffrey Asher had the right to use force in the discharge of official functions, I think that, to a degree, might mitigate the concern over the traditional self-defense and defense of others instruction that was given.
The instruction specifically you asked for was what, or not, or your colleague asked for, is?
Trial counsel had asked for, and it's contained in the record, the written jury instructions. Trial counsel had asked for essentially not only the traditional instructions of self-defense, defense of others, had also asked for an instruction on Jeffrey Asher's status as a police officer, and in effect the police privilege instruction. The judge indicated before the charge conference concluded that she was going to be instructing on resisting
I
arrest.
thought that he asked specifically for the model code and the district court's model instructions. I thought the request, as I recall, was specifically for the district court's model instruction on that.
From the defense?
Yeah.
I believe in addition to the model instruction, there are other cases and authorities cited in the proposed jury instructions submitted. But in theme, it was this issue of Jeffrey Asher's status as a police officer that was being requested.
I mean, there was some colloquy about, or discussion about it, and the response was, oh, something like that from the defense. I mean, there wasn't, I'll look more again, but I don't really recall that there was a specific, it's just that the model code doesn't really address your circumstance?
Correct, to an extent, and I think the judge also, to get to your point, Your Honor, the written instructions that were proposed by the defense made myriad references to the fact that Jeffrey Asher's status as a police officer entitled him to use force. During the course of
Force or deadly force?
I think it was both in the proposed instructions.
Okay.
The judge then, during the course of the trial, indicated she had received the proposed jury instructions from both sides and then gave counsel her proposed instructions. Her proposed instructions did contain the model jury instruction with one caveat on police privilege.
Right.
There is a sentence at the end of the model
Right, it
jury
doesn't apply to
instruction.
the circumstance. It applies
Correct.
to
Because of the
a non-officer in the other side.
That's correct, Your Honor. So she did make that modification. To Chief Justice Gantt's point, I think that if the police privilege instruction had been given, as the judge indicated she would do, that does militate against the normal self-defense and defense of others instructions from having been given. I think if the judge was going to instruct on police privilege, she had a bit more work to do to modify the self-defense and defense of others instructions as she did with the police privilege
But would he be entitled as a police officer to use deadly force except to protect him or his fellow officer from the use of deadly force in this circumstance?
He would be entitled to use deadly force, if we're looking at the model penal code avenue, in order to effectuate an arrest, if this court does adopt the model penal code. For a violent underlying violent felony, that's the model penal code avenue. He also would be entitled to use deadly force to meet the threat of deadly force, which is what this case is concerning.
And isn't that the instruction effectively he received, is that you can defend another with the use of deadly force when deadly force is threatened against another?
The instruction that was given to the jury did not include any reference to Jeffrey Asher's status as a police officer and the obligation to use force.
And that's my question. Is he any different from anybody else in this circumstance? Can he use deadly force if his fellow officer is not threatened with deadly force?
He absolutely can, Your Honor. And that's the distinction between Commonwealth versus Klein, which deals with a citizen using deadly force in the concept of a citizen's arrest, and a police officer using deadly force. There is very much a blurring of the lines between the two, but a police officer has a greater ability to use force, including deadly force, than a civilian would.
That's true, but didn't Klein, as far as citizens go, say you can only use deadly force when somebody's fleeing, correct? For citizens.
Correct.
Here, we don't have I'm sorry, but it just seems to me, the deadly force, he could use, it's what Chief Justice Gantt says, he could use, like anybody could, to defense of another, And in terms of the model penal code, it would depend on whether he was effecting an arrest for a felony, wouldn't it?
Your Honor, I think the distinction is whether or not there's a duty to retreat. Civilians would have a duty to retreat, a duty to use other means before.
In defense of others?
In defense of others as well. They would have a duty to retreat, if possible. They would have a duty to, at the very least, use other reasonable alternatives available to them before deploying deadly force. A police officer does not and cannot have those same restrictions that a citizen has.
See, by the way, any reference in the proposed instructions to any decisions other than those having to deal with arresting and the use of force. So maybe I'm missing it, but on the pages that I found that included those, if they are here, could you let me know which pages in the appendix I could look at? But
I'm sorry, in terms of what the proposed instructions from the defense were?
Apart from, yes, there are proposed instructions regarding use of force by police and police privilege in the context of an arrest. You are speaking in a broader sense, not in terms of an arrest, but when there is a danger, when someone is saying, regardless of the circumstances, if the policemen are involved, and even if they're just detaining him because he was fleeing from a pat frisk, you're suggesting that the instructions requested would have covered that situation.
From the defense?
Yeah.
Yes, Your Honor.
Okay. Just give me that number later and we can look at it. Thank you.
Thank you, Your Honor.
Thank you very much.
Thank you.
Good morning, Your Honors. May it please the Court, Elizabeth Dunphy Ferris. I'm legal counsel to the District Attorney for Hampden County, and with me today is Catherine McMahon, an Assistant District Attorney for Hampden County. It's the Commonwealth's position that the trial judge did not err in refusing to give the instruction as proposed by the defendant.
Can you tell us where that is and specifically what that instruction was?
Yes, Your Honor. There were 3 times when the defense asked for a quote-unquote police officer status instruction. The first is at the Record Appendix 36, and it's contained at the end of the assault and battery charge. And the precise language was that a police officer can use quote-unquote whatever force is reasonably necessary to effectuate an arrest. And then he went on to request that reasonable force is generally that amount of force which an ordinary, prudent, and intelligent person with knowledge and in the situation of a police officer would have deemed necessary under the circumstances. Further on in the Record Appendix 3839, which is at the end of the assault and battery by means of a dangerous weapon charge, the defendant reiterates that language, which he had set forth previously, but then adds an additional element about resisting arrest and the traditional language of resisting arrest, not in the model penal code language, but in the legal theories of resisting arrest. And he indicates that in the absence of excessive or unnecessary force by an arresting officer, a person may not use force to resist arrest by one who he knows or has good reason to believe is an authorized police officer engaged in the performance of his duties, regardless of whether the arrest was unlawful in the circumstances. However, if the arresting officer uses excessive force in his attempt to subdue the arrestee has the right to use such force as is reasonably necessary to repel such excessive force. The third time the defendant asked for a police status instruction, it stood on its own. And this is where the language of police privilege comes up, because police privilege is the language that's utilized by the model instruction in the district court, 9.20, which is self-defense, and as a subsection 12 to self-defense. The editors have entitled that subsection police privilege, resisting arrest.
What's the record appendix on that one?
At page 49 and 50, Your Honor.
Thank you.
And in that instruction, the defendant's language goes so far as to call Mr. Jones the defendant. He didn't even change the instruction he didn't put in language as the arrestee. He put in language of the defendant, which is the model instruction, that a defendant charged with a resisting arrest who raises a justification of his resisting arrest is based on self-defense. So it is a second prong, and this court the law of the Massachusetts is that when a individual who is resisting arrest wishes to justify his actions on self-defense, the Commonwealth has an additional burden. It isn't the defendant's burden to prove anymore. It's the Commonwealth's burden to prove that the officer did not use excessive or unnecessary force. So in the language that was proposed by my brother below, he asked the judge to instruct the jury that the Commonwealth had to prove beyond a reasonable doubt that Mr. Asher did not act excessively or unnecessary in his use of force against Mr. Jones.
So
It totally turned our case upside down, and it would have confused the jury about competing self-defense interests when it wasn't an issue for this jury. This jury needed to determine whether or not Mr. Asher's unconsented to touching of Mr. Jones' body, number one, was intentional. Did he intend to use a dangerous weapon on him? And was that intent and action justified? And his grounds for justification, both pre-trial and at trial, when he attempted to admit evidence upon the reasonable basis, that is the baton chart, and then the testimony of officers that they were acting reasonably in light of their training and experience, only went to defense of others and self-defense. And emphatically, defense counsel said this is not a resisting arrest case. This is not, in fact, at one point pre-trial, he said, I don't know where that came from.
Could I just ask you on that point? Because I read that pre-trial, that was his position, and I think through at least some of the trial, but certainly when we get to the charge conference and submitting the proposed instructions, he is asking for resisting arrest instructions. So what was the discussion about that in terms of the previous position of this isn't a resisting arrest case?
The Commonwealth indicated to the judge that this wasn't what the case was tried upon, but should, in the light most favorable to the defendant, the evidence suggest, however incredulous it was, that Mr. Jones committed a crime. At most, the crime was assault and battery on a police officer, and that legally did not give him the ability to employ deadly force. And the defendant's instructions only asked for force. They never asked for deadly force or a definition of deadly force. And the Commonwealth's objection in the end was, if the court is going to consider giving this instruction, then we asked that the jury be told that the defendant, Mr. Asher, has a limitation on his use to deadly force, so that the jury could draw some ability to be able to determine when a police officer can use deadly force as opposed to just force within his performance of his duties.
Can I just ask you, I'm a little confused, because you say if there were a crime, it would have been assault and battery on a police officer. What about the, if you take it in the light of the police officer who had another police officer saying, he's got my effing gun, smash him. This notion that the Mr. Jones had a police officer's gun, is that not criminal conduct?
Yes.
Of a felonious nature?
I don't believe it's of a felonious nature. It could be criminal conduct.
Certainly dangerous conduct that
That's the
poses a
distinction,
danger
Your
to
Honor.
everyone.
Yes, and that's the distinction. That's dangerous. First of all, the defendant testified that he did not act to effectuate an arrest. He had no knowledge of what had occurred at the trunk with officers.
He saw this individual being handcuffed, so I assume by another officer. He can assume that there is an arrest going on.
Actually, he began to engage before he saw the officer handcuffed, and in fact, the use of the deadly force.
I'm sorry, he struck him before?
He was handcuffed, yes.
Was it but in the course of attempting to handcuff him?
The testimony was that it was in the
Obviously,
course.
the problem was they couldn't get him handcuffed.
He was on the trunk.
Right.
And prone on the trunk.
And the officer's trying to handcuff him.
Yes.
And He yells, he's going for my effing gun or whatever.
That was Asher's take on it. The other officers had different views.
Okay, well, that's a
And then there's a
jury question.
videotape which suggests that the statement was smash him in the knees.
But in any event, that was the testimony. That's what the other officer said. So
Yes.
we got to go with that.
Correct.
All right, so a seizure, call it an arrest, call it whatever you want. Somebody is being taken into custody. The officer doesn't know, is it a felony? Is it a misdemeanor? Does he have a weapon? I don't know, but all I know is my fellow officer is trying to handcuff him, and he's yelling, he's reaching for my effing gun, or he's got my effing gun, or whatever. Smash him. Do something, right? That's the context.
Yeah, that's the context of the initial 6 blows. It is not the context of the other 20 blows that occur. And so the defendant, and it's important that the defendant didn't ask for the language that he's suggesting to this court that he asked for. He made an argument to the jury in determining whether it was reasonable for Mr. Asher to do what he did, that he met deadly force with deadly force. But he never asked for a jury instruction that had anything to do with when Mr. Asher could employ deadly force. If he had asked for an jury instruction that said if a police officer were to meet danger, we'd be in a much different situation. I don't think I would have had an objection below, because that's Garner. And it was decided in 1985, and the court would have to follow Garner. Even though this court hasn't revisited Klein in light of Garner, because Julian is decided in 1980, the only distinction really between the model penal code as what this court has adopted in Klein and then affirmed in Julian is the distinction of the felony versus misdemeanor, which really comes about because the abrogation of the ability of police to shoot at fleeing felons. And therefore,
right, but it has nothing to do. I mean, what you said to me, you said something that, well, he didn't know whether he was being arrested, whatever. I mean, how is an officer supposed to know, coming on the scene, observing someone being attempting to be taken into custody, resisting, and then another officer saying, essentially, he's going for my gun? But is he supposed to say, I wonder if it's a felony? Is it a misdemeanor? What's going on here?
No, I don't think we're at that stage.
And because he's an officer, he has obligations beyond obligations of a citizen.
He does.
Okay. And was that clear in the jury instructions?
Yes, I think it was. In relation to the defense that was raised, it was both the objective and subjective nature of, in self-defense and defense of others, that it was a person's knowledge in the position that the defendant was in, which was a police officer in the performance of his duties. There is a distinction of arrest versus not arrest, because what was being asked for here was really to transfer the focus of the jury from, and to have the judge say that Mr. Jones was under arrest. He wanted specific language that the jury, it was having the judge comment on what we considered was factual debate for the jury to determine whether or not Mr. Jones was under arrest. It was clear, and it was conceded it was a Terry-type stop, and from the Terry-type stop there was flight. He was caught within 15 seconds, and then there was in the light most favorable to the defendant, no matter how incredulous it was, based upon the documentary evidence in this case and the real inability, the statement alone by Cedrigan, which is, as to Mr. Asher saying why he acted, I was in fear for my life because I believed in imminent harm to myself or to my fellow officers by what Cedrigan said to him, not by what he saw. Now that danger, by the testimony of Trulio, is over after the first 6 blows. There's 3 blows to the head, then 3 blows to the knees. And then there is a backing off of Mr. Asher before there is an additional number of blows upon the trunk, somewhere in the teens, 12 or 13. And then Mr. Jones and the officers get Mr. Jones to the ground, and he's on the ground with one of his hands behind and another officer holding his arm in his hand and another officer nearby, and Mr. Asher goes around to his head and hits him in the head, this time, not because any officer said he could get the gun. Factually, there was no way that Mr. Jones could have grabbed one of the officer's guns at that time. The danger that if it existed...
I understand you have a very strong case here. I mean, that's not the question, really. Let's assume that that didn't happen, that in fact Asher had a flashlight, that what he perceived was happening, and hit the guy, hit the arrested person here, the seized person, and essentially rendered him unconscious with a strike. Mm-hmm. Okay. Any instruction about the police officer privilege or police officer operating within his official duties, the kinds of responsibilities he might have versus another citizen?
Well, the so-called police officer privilege only exists in Massachusetts law in the model jury instruction. The duty of a police officer, as it's interpreted in civil law under Garner from the Supreme Court of the United States in this court's case of Klein and Julian, exists, and if the defendant had asked for an instruction along those lines based upon danger, yes, the jury would have been instructed. The defendant didn't ask for it in this case because he didn't try it on the performance of his duties. He did not, even though he was performing his duties, he tried this case on the theory of self-defense and defense of others. There may be a case where the lines of self-defense and defense of others, when the police officer performs his duties, may diverge. But in this case, they were intertwined. This is not a case where the defendant was not in self-defense.
Could I just ask you this question? In terms of the jury instructions, it's following up on something Chief Justice Gants asked you. Was the instruction about duty to retreat part of the defense of others, or was it only part of the self-defense?
And I see my time is up, Your Honor. May I answer?
I think so. Yes.
Yes, you may.
The instruction of duty to retreat, to my memory, was only in the self-defense portion of the instruction in relation to Mr. Asher. It's important to note that the defendant asked for the instruction on duty to retreat.
Well, it's in the deadly force instruction that the Commonwealth has to prove one of the following three things beyond a reasonable doubt, and one is that he took steps to avoid physical combat before resorting to force.
And that is in the self-defense portion of the instruction.
The deadly force portion of the self-defense portion.
Yes, Your Honor.
Okay. Before you go, I do have a question. Did I don't remember this, was the indictment related to all of the blows or only some of them? What was the precise conduct that was underlying the charge against
it's a complaint,
Officer Asher?
It was a complaint out of the Holyoke District Court, Your Honor.
Complaint, okay.
And there were 2 counts. One was assault and battery by means of a dangerous weapon. All of the blows, the Commonwealth alleged, that were alleged to have been proven by the evidence, and that numbered well over 20, were part of the assault and battery by means of a dangerous weapon.
Okay.
There was additional evidence that while Mr. Jones was on the ground, after he'd been taken into custody, he kicked him.
Okay.
Before he left him. And
that was the subject of a separate complaint?
Yes, Your Honor.
Okay. And that was for another complaint for ABDW?
No, it was, that was the basis of the assault and battery complaint.
Oh, even though it was a shod foot?
Yes.
All right, thank you.
Thank you.